At trial, if an attorney yells out, "Objection, Judge!" is the judge required to render a ruling to decide whether or not the question is appropriate? You want to know the answer? Come join me on a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You may have been watching the Johnny Depp Amber Heard trial. And during the course of that trial, there were many, many instances where one attorney or another would yell out, "Objection!" And now the attorney would pause, stop, and wait for the judge to make a ruling on whether or not the question should be answered. Now, is it important for the judge to actually make a ruling? And what's all this about? I'll tell you what it's about. During the course of a trial, there's a witness up on the witness stand. This witness is giving testimony, evidence to the jury about what happened, about what they remember happening. The attorney who is questioning this particular witness, it's either a favorable attorney, their own attorney, who's doing what's known as a direct examination to ask them open-ended questions, to explain in their own words what happened, or it's an attorney who is adverse, one of the opposing lawyers, now an opposing attorney, who does not like the question, may not like the topic, may not believe that the way that the question is phrased is appropriate. So now, how do you alert the judge to tell the judge, "Hey judge, I think there's a problem with the question"? The way to do that is to voice an objection. Now, you don't just sit there quietly at the table, pick your head up and say, "Objection." No, no, no. In court, in order to get the judge's attention, and in order to speak to the court, the attorney is required to stand up and in a voice loud and clear, yell out, "Objection, Judge!" And now you catch the judge's attention. And what else is the attorney required to do? In just a few words, the attorney is required to tell the judge why he or she believes that the question is not appropriate. So now what happens then? Everybody pauses at that moment. Why? To give the judge a moment to make a ruling. An attorney has thought that there's a problem with the question, and there could be many, many reasons why it's inappropriate. But now, in order to prevent the witness from answering the question, or in order to prevent the attorney from continuing this line of questioning, the opposing lawyer voices that objection. The judge is then required to make an actual ruling. Now, the judge has to make a snap decision about whether or not the question is appropriate and whether the witness has to answer the question. Now, how do they do that? The judge is likely going to say either objection sustained or objection overruled. In some rare instances, the judge may ask the attorneys to approach the bench and ask the attorneys for legal argument about why this question is appropriate, why the question may be relevant, why it's now important for this witness to go ahead and answer this question. And the judge takes legal argument. In some instances, the judge is actually going to ask the attorneys for a legal brief, legal research, before he renders a ruling on this particular issue. Now, most likely what will happen is the judge will render a snap decision, and the judge has to decide whether the question is appropriate. And if it is, he'll tell the witness to go ahead and answer. If he thinks it's not appropriate, he'll go ahead and say, "Mr. Witness, do not answer the question. Counselor, ask your next question." And if the judge thinks that the question is appropriate, he's going to say, "Your objection is overruled, counselor," which means I am overruling you. As the judge, I have the right and the ability to overrule whatever objection you perceive this question has, right? In that instance, you, the witness, now have to answer the question. What happens, though, if the judge agrees with the lawyer who is objecting to the question? In that instance, he's now going to say, "Objection sustained." And what that means is, "Yes, counselor, I do agree with you that this question is not appropriate. So I'm going to sustain and uphold your objection," which means the defense attorney should not be permitted to ask that question, and the witness is not to answer the question. Now, ask your next question, counselor. So it's critically important that the judge actually render a decision. Now, you might be asking why. What's the big deal? First of all, the judge controls what happens in the courtroom. The judge controls the pace at which things happen. The judge controls which witnesses are allowed or not allowed to testify, as well as what evidence comes in before the jury. If the judge feels that certain testimony is not appropriate, he's going to stop the witness and stop the attorney from presenting certain evidence. The judge has great discretion and great latitude about whether or not to admit or to keep out certain evidence. Here's why it's important that the judge render a decision for each time that an attorney yells out objection. If an attorney loses the case, now in order to appeal the case, they have to go back through the trial transcript and look to see if there are any errors of law that the judge made. If a topic came up that the attorney felt was inappropriate, and now the judge failed to make a ruling, well, guess what? Now he cannot appeal that particular issue. Why? Because the judge did not make a ruling, and there can be no error of law where the judge hasn't made a rule. He hasn't made a ruling. In that instance, there's nothing to appeal from. So you could not make an argument to an appellate court that says, hey, during this question and this series of questions, I asked the court to stop this witness from testifying, to stop the attorney from asking these questions. The judge should have made a ruling, but didn't. I want the court to go ahead and turn over the verdict and change the verdict based upon the fact that this judge should have made a ruling. And it was error, legal error, to go ahead and allow this testimony to come in. You know what the court is likely to say? That the attorney did not preserve that issue for appeal. Why? Because the judge never made a formal ruling. In that instance, there's nothing to appeal from. Yes, you disagree that the question should not have been answered. Yes, you disagree that the judge allowed this information to come in. But guess what? The judge implicitly allowed this information to go forward, but he never made a formal ruling. And because of that, there is nothing for you to appeal. So it is critically important that if an attorney believes that something is amiss, something is wrong with the question or the topic or a piece of evidence coming in, it is critically important to get the judge to make an actual ruling so that now, if he loses the case later on down the road, he can go back to the trial transcript to evaluate whether or not the admission of this testimony or the admission of a particular piece of evidence may have caused the tide to change and may, in fact, have altered the outcome of this particular case. In that instance, it is critically important to get an actual ruling from the judge so that now he can try and appeal that if he loses later on. So why do I share this quick information with you? I share it with you because this comes up so often in every single case that we see involving medical malpractice, accident cases, and even wrongful death cases in New York. There will be always instances where somebody does not like a question, where somebody does not like a piece of evidence, and now they are asking the court to keep something out. And if the judge fails to make a ruling, well, now you know it may be a problem if they wind up turning around, losing the case, and trying to appeal that issue. You know, I realize you likely have questions or concerns about your own matter. If you are thinking about bringing a lawsuit but haven't done so yet and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.